Hello, my name is Stephen Pivar, and today we're going to be talking about tribal sovereignty. This is part one of a three-part module on DOI's policies regarding the trust responsibility and tribal consultation. And by the way, behind me is a mural from the main building of the department in Washington, D.C., and it depicts, obviously, Plains Indians, or teepees. The principles that we will be discussing, of course, today apply to Indians and Native peoples throughout the United States. By way of background, I began my career in the field of Indian law nearly 45 years ago when I worked for legal aid on the Rosebud Sioux Indian Reservation in South Dakota for almost 4 years. In addition, I have litigated a number of Indian rights cases. I've taught American Indian law at 3 different law schools in the United States, and I'm the author of a book entitled The Rights of Indians and Tribes, the most recent edition of which was published in 2012 by Oxford University. To get right into things, the first part, or the first module, is tribal sovereignty. And nothing is more important to Indian tribes than sovereignty. Indian tribes, of course, have many rights. They have the right to tax, the right to hunt and fish, water rights. They have rights under various statutes like the Indian Child Welfare Act. But the single most important right and the most cherished right of Indian tribes is the right of tribal sovereignty, the right to be self-governing. It's uniquely important. If tribes were to lose tribal sovereignty, then all else changes. Indeed, for many Indians, tribal sovereignty is as important to them as maintaining the independence of the United States is to most Americans. There are hundreds of statements that have been made by Indian and non-Indian officials regarding the importance of tribal sovereignty. I've selected just one of these from a former tribal chairman, and I'm quoting him here: the reverence American Indians hold for the sovereignty of their tribal governments is absolute. There is nothing more important than tribal sovereignty. In order to understand what tribal sovereignty is and to discuss both its origins and the scope of tribal sovereignty, let's start with a dictionary definition of what is sovereignty. It's important to have an understanding of sovereignty and the concept of sovereignty in order to help us see what tribal sovereignty is. Now, a dictionary definition, and this comes from Black's Law Dictionary, a strict dictionary definition of a sovereign government is a government that is vested with independent and supreme authority. It has the power to make its own laws and to then enforce those laws. So, under a dictionary definition, sovereignty is all or nothing. You are either sovereign or you're not sovereign. You either have supreme authority, and if you don't have supreme authority, then under a dictionary definition, you're not a supreme government or a sovereign government. So when we ask the question then, well, are Indian tribes sovereign governments? There's really 3 possible answers. The first answer, we might say as an extreme on one end, is that yes, Indian tribes are sovereign governments because they have always been sovereign governments, and the United States must relate to them as sovereign governments, same as with England and France. Indian tribes, of course, were sovereign governments long before Europeans first set foot on North America. And many Indians, of course, believe that they still are. Even if some tribes were defeated militarily, that does not mean that they forfeited their sovereignty. After all, in World War II, the United States defeated Germany and Japan, and yet we today view them as sovereign governments. And there are many Indians who believe that Indian tribes must be viewed the same way. Here again, there are countless quotations from Indian leaders and Indian commentators on this subject. I have selected one from a Chiricahua Apache by the name of William Bradford, and he writes, "Indian tribes are independent, sovereign nations whose inherent right to self-determination predates and survives contact with Euro-American peoples. Indian sovereignty is never extinguished." So one possible answer then to the question of are tribal governments sovereign is that of course they're sovereign. They have always been sovereign, and they are still sovereign today. At the other extreme, and many non-Indians believe that this is the correct answer to the question, no, Indian tribes are, quote, conquered nations. As a result, they have lost all of their sovereign authority. They are no different than private clubs like the Kiwanis Club or the Lions Club. And they view a dictionary definition of sovereignty that it is all or nothing, and because Indian tribes do not have full sovereignty, therefore they have no sovereignty. There is a middle ground, however, and this is the ground that has been consistently taken by the United States government, including, of course, the Department of the Interior. And the federal government's position is different than the dictionary definition, and the federal government has believed for over 200 years now that Indian tribes are what are called quasi-sovereign, that they possess, quote, attributes of sovereignty. And I'm quoting here from some Supreme Court decisions that I'll mention in just a few minutes. That Indian tribes retain some of their original inherent powers of self-government, but that tribes are subject to the plenary or full or broad power of the United States. So in other words, the position of the federal government is that sovereignty is not all or nothing, that you can have groups such as the native tribes in the United States that retain aspects of their original sovereign powers, but are nonetheless subject to prevailing federal power. So the United States Supreme Court first developed this middle ground, this theory of sovereignty, beginning in the 1820s in a series of cases. And the doctrine that is now well known, well set forth by all three branches of government, has two main principles. And I've selected one of the more recent Supreme Court cases, United States versus Lara, decided in 2004, to illustrate these two main principles. The first principle is that Indian tribes do retain sovereign powers. They have inherent authority over their members and their lands, and that they retain those inherent original powers unless divested of them by Congress. A quote from Lara, Indian tribes are unique aggregations possessing attributes of sovereignty over both their members and their territory. So that's the first principle. The second principle is that Congress has plenary, full or broad, power over Indian tribes. And here again, quoting from Lara, which summarizes 200 years worth of Supreme Court decisions. Quote, the Constitution, and please remember Constitution, we're going to come back to that. The Constitution grants Congress broad general powers to legislate with respect to Indian tribes, powers that we have consistently described as plenary and exclusive. So those are the two main doctrines of the modern concept of tribal sovereignty, and the Department of Interior policies reflect and enunciate and explain those principles. Interior's policies recognize that Indian tribes have sovereign authority. For instance, as discussed later, DOI's policy on trust responsibility commits the department to ensure the well-being of Indian tribes and tribal members while respecting tribal sovereignty. So that's written into the department's policy. Likewise, the department's separate policy on tribal consultation is based on, and I'm quoting here, recognition of Indian tribes' right to self-governance and tribal sovereignty. So we know then that Indian tribes have an original inherent right of tribal sovereignty. What I would like to do for a few minutes anyway is to discuss where the notion of plenary power comes from. This is a very controversial doctrine. Similar doctrines in other countries around the world dealing with their indigenous populations have raised similar questions, and I feel that it's important to have an understanding anyway of the not only the controversy but the complaint of Indian tribes regarding the doctrine of plenary power. There are many people who believe that first of all, the plenary power doctrine is firmly established in the federal government. All three branches, legislative, executive, and judicial, accept it, enforce it. But it's a doctrine that has been extensively criticized. After all, there is nothing in the Constitution that authorizes the federal government to legislate over Indians. I just read a sentence from Lara in which the Supreme Court said that the Constitution authorizes this. But let's take a candid look at whether it really does. The Supreme Court relies primarily on the Commerce Clause to justify federal control over and legislation over Indian tribes. But that clause says only that Congress shall have the power, quote, to regulate commerce with foreign nations and among the several states and with Indian tribes. So that sentence, honestly, does not give federal power over Indian tribes any more than it gives federal power over England and France. And you have to understand, of course, that the Constitution was written in 1787, when Indian tribes were enormously powerful. I doubt whether, and no one has, to my knowledge, found any evidence that the authors of the Commerce Clause, the framers of our Constitution, had any concept that when they identified the branch of government, Congress, as the repository of authority to regulate commerce with foreign nations, the states, and Indian tribes, that any of them felt that what they were doing with those words were authorizing the federal government to legislate over and to use plenary power over Indians. A number of, especially Indian but also non-Indian, commentators and tribal leaders have criticized, strongly criticized, the plenary power doctrine. And let me just read three quotations, and after that we will move on. The plenary power doctrine is an accepted doctrine, but I feel it's important to spend a few moments in discussing its background. One author, Walter Echohawk, a Pawnee, recently wrote, "The plenary power was seemingly plucked out of thin air by the Supreme Court." And again, that's because there is nothing in the Constitution itself that confers plenary power on any branch of government over Indian tribes. Another author, Frank Parmersheim, a law professor at the University of South Dakota, "The plenary power doctrine was adopted by the Supreme Court to justify, quote, federal land acquisition and power in Indian affairs." And lastly, the same William Bradford, who I quoted from earlier, wrote that the plenary power doctrine has its origins in medieval era traditions of Christian cultural racism and was developed to permit the superior race to exercise whatever power necessary to civilize the Indians. In any event, the plenary power doctrine is well established. I sincerely doubt that the United States government will ever abandon it, and I'm not going to refer to that any further in terms of whether it's a valid policy or an invalid policy. It simply is what is the law today. What I'd like to do now is to give examples from Supreme Court cases, illustrating both the scope of the plenary power doctrine and to also reinforce the notion that in those situations where Congress has not limited tribal powers, that Indian tribes retain their inherent authority. So again, I'm going to illustrate the two principles that I started out with, that there is a plenary power doctrine, but that Indian tribes retain their inherent sovereignty. The two cases that I've selected to illustrate the plenary power doctrine are Worcester versus Georgia, decided by the Supreme Court in 1832, and Lone Wolf versus Hitchcock, decided in 1903. Worcester versus Georgia is probably the single most important case in Indian law. So it's important that we have some understanding of it. And it created really both doctrines, or it recognized both doctrines, inherent tribal sovereignty on the one hand, and Congress's plenary authority over another. And the basic facts of Worcester is that Congress, in a treaty with the Cherokees, had set up a reservation for them within the state of Georgia. This was in the early 1800s. Georgia, as you might imagine, this is pre-Civil War, when it was not well established that states had to abide by federal law, and many states were most resistant to doing so. And here Congress comes along and enters into a treaty with the Cherokees, takes, quote, takes land within the state of Georgia, creates a reservation for the Cherokees, and then instructs Georgia to basically keep its hands off, that Georgia could not extend its laws into Indian country. Well, Georgia rejected that concept and passed a series of laws designed to not only to test the mettle of the federal government, but to test its ability to regulate activities within Indian reservations. So one of these laws said that no person could enter an Indian reservation without getting a permit from the state of Georgia. Well, Samuel Worcester was a white missionary. He had been invited by the Cherokees to set up a mission on Cherokee land. He entered the reservation. He did not bother to obtain a license from Georgia, believing that he didn't have to. And Georgia, to show its force, sent its police onto the reservation, arrested Worcester, took him off the reservation, prosecuted him under state law for violating this permit ordinance, and as a show of force, sentenced him to the maximum punishment of 4.5 years at hard labor. He appealed his conviction to the United States Supreme Court, and in a historic ruling in 1832, the U.S. Supreme Court established what is still today the basic principles of federal Indian law, that Indian tribes have inherent sovereignties or inherent authorities, but that Congress could change that balance. And here's a quotation from the Supreme Court in Worcester versus Georgia. And I'm quoting, "Indian nations had always been considered as distinct, independent political communities, retaining their original rights as the undisputed possessors of the soil from time immemorial. The Cherokee Nation then is a distinct community, occupying its own territory with boundaries accurately described in the treaty, in which the laws of Georgia can have no force, and the citizens of Georgia have no right to enter, but with the assent of the Cherokees themselves, or, and this is the plenary power doctrine, in conformity with treaties and with the acts of Congress." So Worcester versus Georgia was good news and bad news for Indian tribes. It was good news because they won. They established the fact that, at least in this instance, Georgia has no force in Indian country. But the underlying seed, the plenary power doctrine, was also espoused in Worcester versus Georgia, that Congress could change all of that. Tomorrow, Congress could pass a law authorizing Georgia to have complete control in Indian country. The next case to illustrate the plenary power doctrine, Lone Wolf versus Hitchcock, decided in 1903. And here are the underlying facts of that case. In 1867, two tribes that had been placed on a reservation, the Kiowas and Comanches, were asked to sign a treaty with the federal government. And they were very savvy, very astute tribes. And they had seen what had happened to other tribes that had signed treaties with the federal government in which the government promised that no further land would ever be taken without the consent of the tribes, or for as long as the sun shall shine and the river shall flow, the tribes will never lose any additional land. And yet, they had witnessed the fact that the federal government often broke those promises. So what they did, and they thought that this would be an added protection, is that their treaty states that no additional land could ever be taken from those tribes unless the federal government convened an election and 3/4 of the adult male members of the tribes voted in favor of relinquishing more territory. And they felt quite confident that tribal members would never agree to do that, and that therefore this was going to be their protection. Well, again, this was signed in 1867. In 1871, Congress passed a law prohibiting all treaty making. So there are some 400 treaties that have been entered into with Indian tribes, none of them after 1871. After 1871, Congress exercised its plenary powers by passing statutes. Well, one of these statutes that Congress enacted after treaty making ended removed a large portion of the Comanche and Kiowa reservation. in direct contradiction to the promises made to those tribes in a treaty. The federal government at first tried to get the tribal members to agree to relinquishing additional lands, and the government couldn't get the 3/4. So rather than continue trying, they simply passed a statute, breaking the treaty and taking the land anyway. The two tribes filed suit against the federal government for breach of the treaty, as you might expect them to do. In what is clearly one of the main cases of the plenary power doctrine, the U.S. Supreme Court upheld the right, authority, power of Congress to pass a statute that breaks an earlier treaty. And what the Supreme Court held, and I'll show you a couple quotations in a moment, what the Supreme Court held is that in the same way that one statute can repeal or change or modify an earlier statute, one statute can also repeal, modify, or change an earlier treaty. That treaties, the Supreme Court held, have the same dignity as federal statutes. And Congress can change a treaty, can abrogate or revoke an earlier treaty merely by passing a statute. So here are some quotations that illustrate the plenary power doctrine. Plenary authority over the tribal relations of the Indians has been exercised by Congress from the beginning. The power exists in Congress to abrogate the provisions of an Indian treaty. And lastly, in view of the legislative power possessed by Congress over treaties with the Indians and Indian tribal property, we may not specially consider if Congress did the right thing. In other words, this was a hands-off decision. These matters are solely within the domain of the legislative authority, and its action is conclusive upon the courts. There have probably been, 400 cases dealing with aspects of the federal government's plenary power over Indians, and we can spend weeks discussing them. I've selected these two just for illustrative purposes so that you can see the reach of the plenary power. As some of you, or maybe most or all of you know, there was even a period from 1953 to about 1966 in which Congress terminated, politically dissolved 109 Indian tribes. Fortunately, Congress has reconstituted nearly all of them, but the mere fact that Congress terminated those tribes illustrates the vast powers that Congress claims under the plenary power doctrine. Let's shift focus now and look at some examples of inherent tribal authority so that we do understand that there are these two main principles. And I've selected three cases of many. The first is Worcester versus Georgia, which we've already discussed. To quickly summarize, the Supreme Court reaffirmed there that Indian tribes have original powers, and that unless and until Congress takes some action to diminish or eliminate those powers, Indian tribes have the same right to continue exercising those powers as they have always had. Another example is Talton versus Mays, decided in 1896. And here are the basic facts of Talton. The Cherokees, who were in Georgia, as some of you probably know, were forcibly removed in one of the bleaker periods in our history, sometimes called the Trail of Tears, in which really at bayonet point, many tribes from the southeast were forcibly removed from their ancestral lands and marched to what then was Indian Territory, now the state of Oklahoma. I mean, you could imagine how difficult that would be, walking from Georgia or Florida to Oklahoma through all kinds of seasons. And many perished along the way. In any event, the Cherokees are now in Oklahoma and have established a very sophisticated law enforcement system, including a sophisticated court system. Talton was a member of the tribe, and he was arrested by tribal police for allegedly murdering another Cherokee on the Cherokee Reservation in Oklahoma. He was prosecuted in tribal court, and I want to emphasize tribal court, found guilty, and sentenced to hang. He appealed his conviction to the United States Supreme Court. And his basic argument was that not all of the rights that he would have received had he been prosecuted in a state or federal court were provided to him by the tribal court. And he felt that that violated the due process clause of the Fifth Amendment to the Constitution. In other words, a tribal member being prosecuted in his own tribal court claimed that he was entitled to the protections of the United States Constitution with respect to his own Indian tribe. And that was the issue. Do tribal courts have to afford their members in tribal prosecutions the same protections that those members or anyone else would have by virtue of the United States Constitution prosecuted in a state or federal court? The U.S. Supreme Court ruled in favor of the tribe and rejected Talton's argument. The Supreme Court held, and we'll look at a couple quotations in a moment, that Indian tribes are inherent sovereignties, long predating even the United States Constitution. Indian tribes are not required to conform their judicial systems to state and federal systems that are governed by the U.S. Constitution. So Indian tribes then have the inherent right to have whatever judicial system they want. And here's a quotation from Talton. "It cannot be doubted, as said in Worcester," so this is going back to Worcester, "that prior to the formation of the Constitution, treaties were made with the Cherokee tribes by which their autonomous existence, that is, their inherent sovereignty, was recognized. And in that case, Chief Justice Marshall also said, the Indian nations had always been considered as distinct, independent political communities, retaining their original natural rights. Because the powers of local self-government enjoyed by the Cherokee Nation existed prior to the Constitution, they are not operated upon by the Fifth Amendment. There was nothing in the Constitution, for example, that requires Indian tribes to comply with the provisions of the Constitution itself. Now, as a quick footnote, in 1968, Congress passed a statute called the Indian Civil Rights Act, ICRA, that does require tribal governments and tribal courts to provide to all persons subject to the jurisdiction of an Indian tribe most, but not all, of the rights contained in the U.S. Constitution. So today, Talton would actually have most of the rights that we would enjoy in a state or federal court. But that is as a result of a federal statute and not as the result of the U.S. Constitution. The final case that I'll briefly mention to illustrate the important principle of inherent tribal sovereignty is a case decided by the Supreme Court in 1987, California versus Cabazon Band of Mission Indians. And this is the gaming case that some of you will already know about. Many states, including California, prohibited high-stakes gaming. And yet in California, some Indian tribes experimented with having high-stakes bingo in direct contradiction of state law. The Cabazon Band started with a relatively small bingo casino. People were flooding the reservation by the busloads, and the tribes kept expanding the size of their operations. California tried to shut them down as violative of state law. The case reached the U.S. Supreme Court, and it's more complicated than this, but the general principle, and I'll show you a quote in a moment, is that the Supreme Court once again viewed whether Indian tribes have the inherent right to engage in any kind of gaming or other operations whatsoever on their own reservations, unless Congress has limited that authority. And here, although these operations might be inconsistent with state law, they were not inconsistent with federal law. So when I read this quote, keep in mind that the Worcester test has been modified over the years. Worcester really asked one question back in 1832. Did Congress prohibit this? If Congress didn't, then the tribe was allowed to engage in it, or I should say Georgia had no authority to act in Indian country. Now, as you'll see from this quotation, the doctrine of tribal sovereignty is involved in a balancing test. But nevertheless, it is a very important feature of the modern doctrine of federal authority and tribal authority. So what the court said, whether California can impose its restrictions on the reservation, quote, turns on whether state law is preempted by the operation of federal law. This is a balancing test, the court said, in which federal and tribal interests are weighed against the state interests at stake. This balancing test, quote, is to proceed in light of traditional notions of Indian sovereignty and the congressional goal of Indian self-government. So we still have, and that's a modern case, more modern case. Another one is U.S. versus Lara. There are many that I could have selected, but all of them reaffirm the principle that Indian tribes retain inherent sovereignty. By way of summary or conclusion, some tribal powers have indeed been expressly limited or even abolished by Congress. But Indian tribes still have vast powers, particularly over their members and territory. Indeed, in the last 40 or 50 years, Congress has passed a slew of laws that are designed to bolster tribal sovereignty. Indeed, there's hardly been a statute dealing with Indian affairs or Indian programs or benefits passed by Congress in the last 5 decades that have diminished tribal authority. On the contrary, they have been designed to strengthen tribal self-government. For example, I've listed a few of them. The Indian Self-Determination and Education Assistance Act of 1975, which many DOI employees will, of course, be familiar with. That's where the 638 contracts come from. In 1975, the Supreme Court, in order to facilitate tribal sovereignty, passed a law saying that Indian tribes could apply to federal agencies and receive all of the monies that were earmarked by Congress to those agencies to operate a particular program. And now those funds could come directly to the tribe, and the agencies would have a supervisory role over the actual expenditure of those funds. The Indian Child Welfare Act of 1978, another historic law designed to strengthen tribal sovereignty by giving Indian tribes a far greater say in custody proceedings in state courts, where state officials are attempting to remove Indian children from their families and from their tribes. Another important law, the Duro Fix. The Supreme Court had decided in a Supreme Court decision that Indian tribes do not have criminal jurisdiction. That is, they cannot arrest and prosecute in a tribal court non-member Indians. That is, an Indian who's a member of another reservation who commits a crime on that tribe's reservation. That tribe, the Supreme Court said, could not arrest and prosecute that non-member Indian. Congress passed a law, it's known as the Duro Fix, because the Supreme Court case was Duro versus Reyna, authorizing and recognizing that Indian tribes do in fact have the inherent authority to arrest and prosecute non-member Indians. Another important law, the Tribal Law and Order Act of 2010, enhances the punishments that tribal courts can impose on lawbreakers. And another very important decision, the Violence Against Women Reauthorization Act of 2013, recognizes that Indian tribes may exercise criminal jurisdiction over non-Indians who commit certain domestic crimes against tribal members. I thought I would end this session, this module, by citing from one quotation from a fairly recent court decision. The issue in that case, or in this case, National Labor Relations Board, NLRB, versus the Pueblo of San Juan in New Mexico, the issue there was whether or not this Indian tribe, a Pueblo, needed to comply with New Mexico's laws regarding unemployment compensation. And similar to what the U.S. Supreme Court had decided 200 years earlier in Worcester versus Georgia, the 10th Circuit Court of Appeals held that because Congress has never required the Pueblo or tribes to comply with these kinds of state laws, then they are free to ignore them. And this is what the 10th Circuit had to say. Indian tribes are neither states nor part of the federal government, nor subdivisions of either. Rather, they are sovereign political entities, possessed of sovereign authority not derived from the United States, which they predate. Indian tribes are qualified to exercise powers of self-government by reason of their original tribal sovereignty. So Indian tribes then are indeed sovereign governments. The fact that the federal government, Congress, has plenary power over them doesn't change that fact, and the Department of the Interior respects those two principles. That concludes this first session, and I thank you for your attention.